The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. Ready to hear argument in our first case, 22-4187, United States versus Colon. Is Englert?
Good morning. May it please the court. I'm Cecilia Englert, and I'm counsel to Jose Cruz Colon. I'll be arguing the jury selection issue, and I'd like to reserve 2 minutes for rebuttal. The Sixth Amendment guarantees criminal defendants the right to a jury drawn from a fair cross-section of the community. To make out a prima facie violation, the defendant must show that there's a distinctive group in the community, that representation of that group in the jury panel is not fair and reasonable, and the underrepresentation results from a systematic exclusion. Most cases raising a fair cross-section requirement or a violation are centered around the use of voter registration lists. Courts recognize that no system's perfect and are willing to accept some discrepancies. This court in Cecil upheld the use of voter registration lists.
Counsel, before you get into the distinctive group issue, don't we have a threshold question of whether the Sixth Amendment cross-section provision even applies to petite juries? And Lockhart seems to say they don't pretty clearly, and in Holland versus Illinois seems to affirm that. How do you get past those on a threshold basis before we even look at the three-part test?
So the appellant's argument is not that their argument is that they were not allowed to even select an unvaccinated juror to be on the panel, and that is systematic exclusion from the jury panel, from the venire. And so this is different from the case in Holland. It's different from saying, looking at your petty jury and saying, well, no member of this community is on that jury. What happened was that the district court would not allow any of the unvaccinated people to be selected at all.
But, I mean, we have similar cases where jurors are on the veneer, they make it to the pool that's being considered, and then a judge strikes them instead of either party. And we have case law that addresses that, but that's not a fair cross-section problem. That's, did the judge abuse his discretion in striking a juror on his own?
So when the judge is looking at the entire panel of jurors and then begins to ask questions and strikes as a result of different reasons for that person not serving, that is different from a blanket exclusion of unvaccinated jurors. And it has come to the point in the same district court where instead of this process that we had here, the judge has, Judge Novak has asked the clerk to simply strike or not send forward the unvaccinated jurors. So this is a blanket exclusion from the venire.
Well, that's not, that may be, maybe that what has happened since then might change things a little bit, but here, the unvaccinated jurors aren't excluded from the pool of jurors. They come, that they're asked, and they're part of the group. If I'm asked, this is a question, so if I have it wrong, please correct me. But they're asked in the questionnaire whether they're vaccinated, and then the list of jurors is put together, and then there is strikes, some by the court and some by the parties. So they're not excluded from the full veneer. excluded once the group or the pool is established, it seems to me. Is that not right?
Again, because they were struck entirely based on vaccination status.
Right, but from a factual standpoint, is Judge Quattlebaum's question answered yes or no?
Whether this is really a petty jury question versus,
No, I thought the question was the composition of the jury pool, and then it goes through the court process to get down to the petit jury. Weren't all these people included in the initial pool?
well, I think that it's,
Well, either they were or they weren't. I don't know that it requires an explanation.
they were
Okay.
in that pool in this case, but it would be like bringing in the jury panel and saying, well, all women, you can leave now. And then we're going to compose
Well, am
our,
I right that you or whoever was trying this case disclaimed the Batson claim?
that's correct. It is a fair cross-section claim.
So, going a little farther down the line, my recollection is almost all of these cases where there's relief granted involves some class where there's an immutable characteristic. There's nothing they can change about it. But that doesn't seem to be the case here.
Well, I would go back to the Supreme Court case in Thiel, which was an exclusion of all daily wage laborers, and the court rejected that exclusion and said that the blanket exclusion of any one group damages the jury trial as an institution. I would like to emphasize that intentional discrimination, intentional exclusion is different from a case where there's a challenge based on a disparity drawn from the voter registration lists.
Counsel, without just one more question on this kind of threshold issue and how we look at it. Now, I think I understand your point, and assume hypothetically that at least under the record here, we, Lockhart and Holland, compel, finding that the Sixth Amendment cross-section provision doesn't apply here. Would the only way to challenge what happened after that be an abuse of discretion, trial management type argument?
Well, I think that would be ignoring the fair cross-section issue and the fact that these people were not allowed to even be considered for the jury, for the petty jury.
Okay.
I would go back to the Supreme Court's admonition that when a blanket exclusion is applied, that a distinct quality is lost in the petty jury. And here we would argue that a prima facie case was made, that just by excluding these people, the district court made a distinctive group. And because it was a direct exclusion, that the rest of the Duren factors are met, that there were no unvaccinated people on this jury panel. And it was because of the systematic exclusion by the district court. Although the district court was trying to prevent the spread of COVID, its questions were not narrowly tailored to preventing the spread of COVID. The district court did not ask the vaccinated if they lived with any unvaccinated individuals who could have prevented a larger risk. The court did not ask any of the unvaccinated individuals if they might have had a recent or recovered from a recent infection and had natural immunity, or if those people had recently tested negative for the virus. I would also request that the court consider the damage to the institution of the jury trial by excluding a significant portion of the community from serving.
All right, thank you very much, counsel. You've got some rebuttal time. Mr. Groeni, did I pronounce that correctly?
Precisely, Judge. Thank you very much. May it please the court. My name is Fernando Grueni. I actually was the one who raised that issue at trial. I represented
Raised which issue?
the issue that Ms. Engler just argued.
Okay.
And I'm actually have the other issue, but if I may, I understand. I haven't been in this court in a little while, but I understand that facts are important. The law, you and your law clerks are very familiar with. The facts are sometimes important and actually determine what law is applied to it. So what I would say with regards to the issue that Ms. Engler was discussing with your honors is that if you look at the record, if you look at Joint Appendix 58, 61, and 63, the trial court actually, the defendant, Mr. Cruz Colon, and his wife, Ms. Lopez Alvarado, my client, were actually out on bond. So prior to trial, the judge inquired as to what was the vaccination status of the defendants. We informed the court that they were unvaccinated due to deeply held religious beliefs. So we needed to brief the issue. Joint Appendix 58 deals with that. In Joint Appendix 58, we actually, co-counsel and I wrote to the court that due to the beliefs of our clients, they refuse to be vaccinated. However, they will comply, and that's the other issue. Chief Judge Davis had actually issued a slew of orders, standing orders, that manage the COVID crisis, or attempted to manage the COVID crisis during the pandemic period in the Eastern District of Virginia. Those orders are actually, reference to those orders are included on the record in the position that I issued to the court. For instance, Chief Justice Davis said lawyers, their staff, people who work at the courthouse either should get vaccinated or wear a mask or take a test and prove within a certain period of time and prove that those tests were negative. That's exactly what happened with our clients. However, when it came down to selecting the jury, we, the defense, the prosecution, and the judge mutually agreed to exclude, I think, 5 prospective jurors from the veneer for who were unvaccinated for other reasons. However, there was one that we did not exclude for cause, but the judge did. And the only cause was that that individual was unvaccinated. When it came down to jury selection that day to the voir dire, apparently undetected, there was another juror, a prospective juror, who was unvaccinated. That juror was actually excluded by the judge for cause, and the only cause was that he or she, I don't remember, was unvaccinated. So I understand that the standard is whether a fair cross-section of the community is excluded improperly. But what we argue here, I think what Ms. Engler is arguing and the record bears, is that it's the sole fact of being unvaccinated grounds for exclusion for cause. We submit that it is because, as Chief Judge Davis issued in many of those orders, which are cited here, even for the defendants, there were other measures that could have been taken in order to prevent, to effectively manage the court's docket and prevent and ensure the safety of all those participants, the marshals, the courts, the jurors, the lawyers, and the defendants. As to my issue I understand that I have a heavy burden. The jury has ruled, the judge has denied my motion to set aside. Perhaps I should have argued at trial. I shouldn't have gone for all the marbles, and I'm confessing that. I shouldn't have gone for all the marbles, guilt or innocence. I should have said, yes, my client has been proven guilty, but she has been proven guilty of a 5-year sentence, not a 10-year sentence. She has been proven guilty of selling or conspiring to sell between 500 grams of cocaine, not crack, but powder cocaine, and 5 kilograms of cocaine. I went for all the marbles and lost, realizing later that the evidence presented by the prosecution at trial, not in the PSR like the government originally argued in their reply brief or response brief, but not in the PSR, but at trial, was that the government's main witness only can certainly put 2.5 kilograms of cocaine as being reasonably foreseeable to my client. And that falls way short of the 5,000 kilograms, or I'm sorry, 5,000 grams that the law requires in order to impose a sentence of 10 years. I actually believe the court was correct in granting the Rule 29 on its own about striking the heroin component, which was charged in the indictment against my client. But I contend respectfully that the government has failed to prove, or in this case, based upon the evidence admitted, not what's in the PSR, but the evidence admitted, the government failed to prove 500 or 5,000 grams against my client. Thank you so much.
All right, thank you very much. Mr. Cook?
May it please the court. I'd like to start with Judge Quattlebaum's question. The Supreme Court in Holland said that we have never invoked the fair cross-section principle to invalidate the use of either for-cause or peremptory challenges to prospective jurors. So in light of Holland, there isn't a fair cross-section challenge to even for-cause bases for striking a prospective juror after the veneer has been assembled. And overwhelmingly, what happened here can be characterized as for-cause strikes after the veneer was drawn using voter registration lists, which under Cecil are valid. Now, I would say, although I certainly don't want to be taking up the defendant's argument, 2 points on that. One is that the way jury selection happened here was unusual because of the pandemic. Now, in the normal course of things, the clerk's office uses the voter registration list.
So, well, just to go back for a second, your argument would say that if you want to make a fair cross-section claim, that has to be with the initial step of the process where the court is assembling the pool before there's any type of examination of the pool.
That's right, and I think that that helps explain why fair cross-section challenges are pretty scarce. There's not a large body of case law in this circuit about it because what's happened is courts comply with the Jury Selection and Service Act, which says use voter registration, and then Cecil upheld that. And so there really aren't problems arising at the stage of assembling a veneer because the process is just chugging along in accordance with the Jury Selection and Service Act and using a criterion that has been upheld. And then the narrowing of the jury is occurring at the stage of for-cause and peremptory challenges, which takes you outside the scope of the fair cross-section standard. And in light of that, I think that's why you just don't see a whole lot of fair cross-section challenges, because in Holland, the Supreme Court said these later in the process bases for removing prospective jurors are not part of the fair cross-section analysis. Now, having said that, there are features that are unusual, I think, about this process, which is usually what you would see is the veneer assembled, people called in for jury selection, and then the judge would go through for cause and peremptory strikes. Here, in order to eliminate having a very large group of people in the courthouse at the same time, there were questionnaires sent out in advance, and then there was some screening of the jurors before they even arrived at the court. So there is a way in which, in fairness to the defendant, the lines here are a little bit blurred for practical reasons to limit the spread of the virus, simply to avoid having people all in the same room at a large number at the same time. And so you can look at this and say,
But isn't the difference between the being excluded from a petty jury and being excluded from the jury veneer, isn't the difference, if you're excluded from the veneer, you're excluded from all jury service. You can't serve on any jury. But if you're excluded from a petty jury, you can come back or, you might be on another jury. Is that a line that helps us distinguish what happened here?
I think that's an excellent point, Your Honor. And what courts that have used this vaccination status as a basis to exclude people have said, not all of the cases, but some of them, is, look, we're not saying that you'll never serve on a jury. We're saying right now, for this trial, with where things are in the pandemic, we're not having unvaccinated jurors. That is not we've constructed this rule that will forever exclude you from the veneer. And so that, I think, does help move this from the realm of a veneer-type challenge, fair cross-section challenge, into a ordinary run-of-the-mill type of for-cause strike, much like somebody says, I have, in this particular case, I know one of the lawyers, I know a witness, that kind of thing. That basis for exclusion of a juror does not mean that juror will never serve on a jury ever in that district. And so, whereas you look at cases like Taylor and Duran from the Supreme Court, those dealt with rules about women as prospective jurors that applied in all cases forever for as long as that rule existed in that state. And so, for example, one of the rules was that all women had to, in order to serve on a jury, submit a declaration saying that they wanted to be considered for jury service. And that's just a rule that would always apply, and the Supreme Court struck it down. So I think Your Honor is right, that whether you're talking about a rule that is a categorical rule that's going to affect all trials is an important consideration, in addition to kind of timing considerations, like what is the court doing to generate the veneer panel. And in this case, of course, voter registration lists were used. There was a veneer that was drawn, and then they used the questionnaire to start narrowing things down, and some of that happened outside of the courtroom with the agreement of the parties. Some of it occurred inside the courtroom. If the court gets past the question of, is this even a challenge to the veneer, I think it's helpful to look at, there's a collection of circuit cases out there that have used these three factors that I noted in this 28J letter from the 10th Circuit Green opinion that ask whether the group is defined by a limiting quality, whether there's a similarity in attitude, and whether they have a community of interest. I don't think those can be viewed as necessary and sufficient conditions for whether you have a distinctive group, because as the Seventh Circuit pointed out, they're rather poor fit for explaining why some equal protection type classes are deemed groups. I also think that language would have to be read together with a passage in Lockhart that said, we've never attempted to precisely define the term distinctive group, and we don't undertake to do that today. But we think that the concept of distinctiveness must be linked to the purposes of the fair cross-section requirement. And they identified three purposes, which were guarding against the exercise of arbitrary power and ensuring common sense judgment of the community, preserving public confidence in the fairness of the criminal justice system, and implementing our belief that sharing in the administration of justice is a phase of civic responsibility. And Lockhart then went on to apply those and say that when you look at those factors, you can understand how groups like women, for example, would be deemed a distinctive group. Those are obviously fairly open-ended factors as well. And so the distinctive group test is one that is flexible, clearly, and has been relatively narrow in its application. The defendant has an argument that is, look, under Cecil, any intentional exclusion of a group would be a distinctive group. That cannot be right, because we know from the Supreme Court's cases that they found that there isn't a problem with, for example, excluding from jurors in a capital case those who could not apply the death penalty in a case. And that is a defined group who is expressly excluded for that reason, and that's not a distinctive group for purposes of the fair cross-section analysis. Similarly, you can say the same about the voter registration list, which is non-voters have been intentionally or knowingly excluded, and that is not a
But the opposition to death penalty, you wouldn't get that until after you'd already assembled the initial list from, if you're using voter registration, you would
right.
have assembled the initial list before you could get to the point of making that determination.
Right. I believe that in the cases where that gave rise to this, the challenge to death-eligible juries, that there was a filtering process occurring at the stage of the veneer. But in federal court, typically that would not be happening. In federal court, you would be assembling a veneer with the voter registration list and then doing examination of jurors during the jury selection process that would individually take them out. But the principle that the Supreme Court noted in Holland, I think there's a passage there that directly speaks to this, a rule that would say, anytime you have deliberately drawn up a group and excluded it, even at the veneer stage, it's a cross-section distinctive group. That can't be right in light of what Holland says. Holland says that it does not violate the fair cross-section requirement to, quote, disqualify a group for a reason that is related to the ability of members of the group to serve as jurors in a particular case. And I think that goes to Judge Rushing's point, but I also think it fits very nicely with what's going on with the exclusion of vaccinated jurors, even if you were assuming it was taking place at the veneer stage of drawing up a veneer panel. Because the point the courts are making in excluding a unvaccinated juror is that it does affect the ability of members of the group to serve as jurors in a particular case. And when courts have looked at, for example, the criteria in the Jury Selection and Service Act, which again is a provision dealing with the selection of the composition of the veneer, there's 1866 C2, which covers exclusions of jurors who would disrupt the proceedings, and the courts have said, look, if you get sick and you infect other members of the jury, we may have a mistrial. And then they also say that under 1866 C5, the integrity of the deliberations could be affected, which would be a valid basis. I do think that although the Jury Selection and Service Act is aimed at the composition of the veneer panel, that a basis that Congress has put forth as a criterion in the selection of the veneer panel, if you use that and it's appropriate there, it's also appropriate in the context of a for-cause strike. And so I think that those are informative.
What else you got for us, Mr. Cook?
If the court doesn't have any other questions, I'm happy to rest on the briefs.
All right, thank you very much. Ms. Engler, you've got a rebuttal time reserved.
Thank you, Your Honor. I'd like to get back to what the court seems to be interested in, which is whether this was limiting the veneer or the petty jury. And I would urge the court to think about whether this reasoning would be a way to get around entirely of the fair cross-section requirement. If you can, at the stage where you have the jury panel and you're at the point of selecting the petty jury, that you can then, assuming a distinctive group, then eliminate that whole group at that stage and then avoid the entire...
We would review that under an abuse of discretion standard, right? If the judge said, I'm going to strike all the women for cause because I don't think women should sit on this case, we would review that for an abuse of discretion, right?
That, so for striking, at the point where the court is trying to determine whether individual jurors may serve, that is an abuse of discretion standard. But in this case, that pretrial conference was...
I'm not trying to necessarily dispute where the line is drawn here. I'm just pointing out it's not as though we have to accept your characterization of what stage we're at to make sure that this is being reviewed, right? Even if it were at the petty jury stage, we would still review that, and it would seem to me to be an abuse of discretion if a judge said, this is just not a case for women.
I think, though, that you could argue it's an abuse of discretion standard, but I think that if you have a Sixth Amendment fair cross-section claim, that it can also be brought under a constitutional violation standard. May I just very quickly address that if we get to the distinctive group, that it does not necessarily have to be an immutable characteristic. United States versus Reskiewicz addressed reservation Indians, and although it said it was a close call, there is a line in there saying that it need not be an immutable characteristic. In closing, striking all unvaccinated jurors caused irreparable harm to the defendants and to confidence in the criminal justice system. They request that this court reverse their convictions and remand for a new trial.
All right. Mr. Groening?
Thank you, Judge. May it please the court, I would just say 3 quick points. As to the veneer question, once the questionnaires are sent, whoever is not excluded, and the record shows both sides' exclusions, whoever is not excluded is in the veneer. Then there were at least 2 additional exclusions for other reasons, actually for the only reason that these individuals were not vaccinated. As to Judge Rushing's question, would that be an abuse of discretion? Yes, it would be an abuse of discretion, I humbly say. And if we look, and actually Chief Judge Davis's general orders, which were not mandatory, they were, in his opinion, with the research, and they're posted on the website of the Eastern District of Virginia. All of those general orders indicate that unvaccinated individuals are not permitted access to the criminal justice system in any capacity, including as jurors. In fact, he says that depending on the vaccination status of the individual, masks may be removed or not, according to the discretion of the judge. In grand juries, in during jury voir dire and during jury selection or trials. So that applies to lawyers and to everybody. It applies to our defendants, our clients. It applies to prospective jurors. So Chief Judge Davis, in his general guidance, did not prohibit unvaccinated jurors from actually serving. And whether they were prohibited by this particular judge or not, maybe that's a standard that should be reviewed for abuse of discretion. Thank you for your consideration.
Thank you, counsel. We appreciate the arguments from all the counsel in this case. And we note that both counsel for the appellants are court-appointed, and the court wants to express its appreciation for your undertaking representation in this case, because we could not perform our duties unless there were members of the bar like you who were willing to undertake that task. So as you may know, our tradition here is to come down to the well of the court and shake your hands after the argument, but we're still COVID limited, so we hope the next time you're here we can do that. So with that, we'll move on to our next case. All right, our next case, 224397, United States versus Miller. Ms. Harold, we'll hear from you. I would note on behalf of the panel a reminder to counsel that there is a juvenile victim in this case, and so we would suggest refraining from use of any identifying indications like the name of the juvenile, for instance. All right, we'll hear from you.
Thank you, Your Honor. May it please the court, Jennifer Harold on behalf of the United States. In this case, the district court plainly abused its discretion by precluding the United States from introducing any witnesses or testimony at trial beyond a single exhibit, particularly evidence about the victim's age and how the defendant knew her. The charged offense, a violation of Section 1470, required the United States to prove that the victim was under the age of 16 and that the defendant knew she was under the age of 16. Rule 403 prejudice simply does not apply to the basic facts of the offense, such as the qualities of the victim that make the offense a crime. This is doubly true when the Rule 403 balancing test was based on an erroneous reading of Old Chief. The United States had rejected a stipulation proposed by the defendant that he would agree that he knew the victim was under the age of 16, rather than giving the victim's specific age and how he knew her. The court, finding that the stipulation had been offered, found that Rule 403 excluded the United States from presenting any evidence beyond that stipulation. It was a clear violation of Old Chief and a clear violation of the Rule 403 balancing test with regard to undue prejudice when it involves direct facts of the case that go directly to the elements. The court's exclusion of this evidence was not a mere abuse of discretion, but a plain abuse of discretion, as is required to reverse a court's 403 balancing test. This case must be vacant.
If I could interrupt you, putting aside, just for the sake of this question, the Old Chief issue about whether you are required to accept the stipulation or not. So understand the point there, but just for the sake of this question, assume that's not, we're not considering that. Is there, is there authority that addresses in the context here about whether something's obscene, the context of the material as opposed to the content of the material? Because there's might seem intuitive to say, yeah, the age matters, knowledge of age matters, the relationship matters. But is there authority that addresses that one way or the other? That do we look just at the content, or do we also get to look at the context?
It's a little unclear on the guidance. What is clear is that in evaluating obscene material, it's based upon the work as a whole. And in this circumstance, the work as a whole is this individual letter, which was the single exhibit the United States was allowed to present. However, the letter itself provides no clear indication of what is being described. And the specific nature of what is being described can only be shown and demonstrated to the jury by knowing who the victim is, because the letter describes sexual activity between the defendant and the victim. And the victim's particular identity and age are pertinent for the jury to understand what this letter is describing. And for the prurient interest prong, which the United States believes that that issue goes to, one of the factors that a jury is to analyze is whether the conduct described goes to, or is something that would arouse disgust in the average person. And the very reason that defendant argues that this evidence should be excluded is that it would arouse disgust in the jury, which is literally the evidence and the element that the United States has to meet. Obscenity cases are a little unique in that respect, in that the evidence that is necessary to prove the offense is almost invariably going to be prejudicial and disturbing to a jury, but that is not a reason to exclude it. If that was a basis for excluding it, it would be nearly impossible to prove an obscenity case under any circumstances.
So if the letter described these acts with a hypothetical person, right, a work of fiction, that you're saying you don't need to know more than what's in the letter. But if the letter describes the victim, the actual person, and doesn't give us important information about them, information about who that person is relevant to understanding whether this is obscene or not. That if it's describing an adult, a stranger, perhaps not obscene, but if it's describing a child who knows the victim in a particular way or knows the defendant in a particular way, that can make it obscene.
I think I don't want to cover every hypothetical of that,
right.
but I think that what it comes down to, and I think this is the point that Your Honor is making, the issue is that because this was a letter directed from the defendant to the victim, who obviously knows who she is and what their relationship is, it's not written out. If this had been a hypothetical or a scenario where they were writing a story, it would almost certainly include the information. It would describe the relationship between the two parties being described in the letter.
Right. This is not a magazine article. This is not an entry in a book. This is about a particular person, and you have to have that context to understand if it's obscene or not.
Exactly, Your Honor. And particularly in this scenario, the audience, the victim, obviously knew all of that. And the defendant knew all of that. So everyone who was privy to this letter would have known the context. And in order for the jury to determine whether that letter itself was obscene and did appeal to the prurient interest, it can't be left in the dark to something that every other party to the crime was aware of. And so by excluding this evidence, specifically with regard to that prurient interest prong, the jury would have been deprived of critical evidence rather than being told evidence that could arouse an emotional verdict that was based on things outside the context of the crime. Also, in addition to being highly relevant to the prurient interest prong, the age of the victim was obviously an element the United States had to prove, and the court's order precluded the United States from even introducing evidence that she was under 16 or what her age was, unless entering into this stipulation, which it had previously rejected. And the same goes to the defendant's knowledge. Nothing in the letter itself indicates how the defendant knew the victim, or even that he did know that she was under the age of 16. So other than having some evidence outside of this letter, there would be no way to meet two elements of the offense without entering a compelled stipulation, which the United States obviously is not required to do under Old Chief. So this case involves an assumption made that the United States must rely on a stipulation, and then finding that reduces the probative value of the evidence so low that Rule 403 would exclude it. This is an erroneous decision based upon another erroneous decision, which constitutes a plain abuse of discretion. It's obviously a high burden to meet, but this is one of those exceptional cases where the United States believes that plain abuse of discretion was what happened in this case, and the order must be vacated. So no further
I
questions?
understand that the district court also ruled on a ground of relevance, but I take it from the briefing of the parties that's conceded that that portion of the opinion was erroneous.
I believe that is conceded, Your Honor. There were several 403 bases for the exclusion as well as relevance. It appears that everything has been abandoned except for the undue prejudice portion of the 403 analysis.
Okay. You have some rebuttal time.
Yes, I will reserve that, Your Honor.
We'll look forward to hearing from you then. Mr. Page? So
Thank you, Your
is
Honor.
opposing counsel correct, the only thing left here is the unfair prejudice claim under 403?
I think in part, I would submit that it is the evidence of the relationship between Miller and MM is irrelevant to the issue of
I thought
obscenity.
you conceded that the district court's ruling on relevance was erroneous.
We conceded that the district court could not preclude the government from introducing testimony that Mr. Miller knew the defendant and knew how old she was, and that she was 14 years old. We did concede that. We did not concede that the evidence of their relationship was admissible to prove the element of obscenity. There are two different bases upon which evidence of their relationship is sought to be admitted by the government. The first one is to Miller's knowledge of MM's age.
Let me ask you this question. In order to prove some of the necessary elements under this statute, the government's required to prove age, knowledge of age. How would the government do that in this case unless it accepted the stipulation?
And that is what we are conceding, is that the government is entitled to present a witness who can testify, and there was a law enforcement officer in this case who interviewed Miller, where Miller admitted that he knew MM was 14 years old. We concede that the district court abused its discretion in not allowing the government to present that part of the evidence. Where we maintain that the district court was correct and should be affirmed is that evidence of their particular relationship should be excluded, both under Rule 403 as unfairly prejudicial to prove how he knew her age, and irrelevant entirely as to the issue of obscenity. And that's the question I think that Judge Quattlebaum was getting at with his very first question to the government. There is no case law that was cited by the government, no case law that I'm aware of that holds that a jury can consider anything beyond the four corners of the allegedly obscene material to consider the issue of obscenity.
So that means it can't consider her age to decide whether this is obscene. The jury has to think this is, this is obscene whether this person is 30 or whether they're 3.
I would agree with that. Now, in a case
That's
like.
what you think. You think that obscenity has nothing to do with the age of the victim,
Exactly.
whether it would arouse disgust and appeal to the prurient interest.
That's exactly correct, Your Honor.
What's the authority for that?
Miller itself says that the average person applying contemporary community standards must determine
Would the
whether.
average person applying contemporary community standards think that sex between a 30-year-old, two 30-year-olds, and sex between a 30-year-old and a 3-year-old is the same?
That's not the issue, Your Honor. The issue is whether the average, if within the four corners of the material, okay, it described sex between an adult and a minor, then yes.
How do you know it's a minor?
In this case, we don't, and in this case, you really can't get away from that issue. The jury's going to know that this was written to a minor. It was a letter. The facts were that it was transmitted to a minor, to a 14-year-old.
And Congress thinks that that is criminal, that the age matters because it makes it, it puts it in a different category. Now, that's a separate element, right, that he knew the age.
That's
But I
correct.
don't see how you get around the definition of obscenity here.
The definition of obscenity has to be the same regardless of. The definition of obscenity has to be the same regardless of to whom the material is sent. The statute says.
Right, but that's not
transmitting-
what we're asking. We're asking, what is the material about? What is it describing? What
Just-
acts is it describing? And the person who the acts are happening to is relevant in understanding what is this letter describing? Not just who gets it, who happens to read it, but what is it describing?
Only if that information is present in the material itself. If this letter, instead of being sent to MM, was erroneously mailed to somebody else, and that other person receives it and picks it up, they need to be able to determine whether it's obscene on its face without knowing who it was intended for.
What authority do you have for that besides Miller itself? Because, I mean, I did ask your colleague that, but I want to ask you. I mean, the letter, for example, I'm not going to go into anything specific, but it does talk, I'm going to do these things to you. So it's, how does, you're saying, it seems to know who, that a jury would need to know who you is to understand the letter. You seem to say no, you just get to look at the four corners. I accept that argument, but what tells me you're right?
Your Honor, based on my review of the cases cited both at the district court level and in the briefings before this court, the only case that I found that was at all touched on that issue was the Sagehorn case. And I apologize, I don't have an exact cite for it. It's a District of Minnesota case, and it addressed a tweet. There was a tweet that said, did some particular student make out with a teacher? And the response was, it was basically a concession by the student. And what the district court looked at in that case was whether the word make out was offensive, was obscene or not. It didn't consider the impropriety of the relationship between the student and the teacher. It looked at just the words itself. That's the only authority that I've been able to come up with. I would submit that it's the government's lack of authority that we can consider more is more telling. And I would.
So I assume that based on your answer with regard to the factor of age, it would be the same with regard to a factor of relationship.
It would, Your Honor. And again, that's part of the problem with this case. You can't take out of the jury's knowledge that this letter was written to a minor. But that shouldn't be part of the consideration of whether it was obscene in the first place. We can and should excise the issue of the relationship between Miller and the minor because that is unfairly prejudicial and irrelevant still. I think a jury instruction would be appropriate to tell the jury that they cannot consider the relationship between the two as an adult and a minor in determining the issue of obscenity because that's not within the four corners of the document. And I've thought through, I've tried to think of some hypotheticals to illustrate this. One that I thought of last night was the Beatles song Lucy in the Sky with Diamonds. It's on its face an innocuous, innocent song. If the listener has more information, you figure out that's a song about drugs, about LSD. But we can't rely on that to determine whether the song on its face is obscene or not. Another example I came up with would be some sort of pornographic material that's not otherwise obscene, okay? If the average person applying contemporary community standards watches that video and does not believe it to be obscene based on the Miller test, if that person later finds out that the two people in the video were brother and sister, I think we would say that's probably obscene, but you can't consider that. You can't consider individual facts that the recipient may or may not know. It has to be obscene on its face. That's the way the statute is written. It says transmits obscene material to a minor. It has to be obscene first. Transmit it to the minor does not transform it from not obscene to obscene. And Congress, I think, would know how to apply a different standard when material is sent to a minor. One of the cases that was cited within Miller itself was a previous Supreme Court case, Ginsburg. And in that case, the Supreme Court examined a statute that made it illegal to provide obscene material to a minor, and within that statute defined obscene material as appealing to the prurient interest of a minor, and further defined what would be obscene to a minor. So Congress knows how to change the standard for obscene material in different contexts, and they didn't do that in this case.
I mean, I don't think anyone's here is arguing we look at this from the recipient's subjective state of mind. What you're looking at is to determine whether the letter is obscene. You get the benefit of, I would say benefit. Does the fact that pronouns are used, keep you from being able to, keep the jury from being able to understand who it was sent to, which keeps them from really understanding the content of the letter. I think that's the issue. Is here, the question is whether when it's framed in a with pronouns, does the information you seek to exclude really distort the content in some way, or hide the content?
I would say no, because this is still a transmitting obscene material to a minor. The jury can determine on its face whether the way that Miller described the sexual acts was obscene or not, and the fact that he had some relationship with her doesn't change what was on the face of the document. A person picking this up on the street needs to be able to determine on its face whether it was obscene or not. And what Miller and the obscenity cases that it discussed, the problem it was addressing was providing pornographic materials, hardcore pornography, and things of that nature to minors and to people who didn't want to receive the material in the first place. Miller involved the unsolicited mailing of otherwise obscene material. It was a mass mailing to people who weren't looking for it. And the question was whether, I think it was the state of California, had the ability to even regulate that speech or not. And the only reason that it had the ability to regulate it was because it was obscene in the first place. And so that's why I would submit that you have to stick to the four corners of the document. The other ground that the government raised as to admissibility was that it was probative of Miller's knowledge of MM's age. First off, that's not, how he knew her age is not an element. That he knew her age is, we offered to stipulate to that. The government is not required to accept that offer to stipulate, but it's very clear that Miller readily admitted that he knew her age to be 14 when he was interviewed. That element is not fairly in dispute. And the district court was...
What about the language in Old Chief and all these other cases that says you can't hamstring the government in telling the full story of the particular event. You can't interrupt the narrative, to use that language.
Well, this isn't part of the narrative, and what Old Chief did recognize, the government's ability to put on its case as it sees fit notwithstanding, there are certain circumstances where the probative value of a piece of evidence is so small and compared to its prejudicial effect that it may rightly be excluded. And Old Chief obviously recognized a quintessential example of that with the fact of a prior conviction in a felon in possession type case.
Right, which went to status, not so much as to a narrative.
Correct. And that's one of the reasons why the evidence of a prior conviction in a felon in possession case has such little probative value. We would submit that in this case, the evidence of the relationship between Miller and MM is also of very little probative value given his admission on that element when he was interviewed. This is not a contested element where the government needs to build inferences in order to prove that, particularly when the way that it would build those inferences is so unfairly prejudicial. And if you look at the cases that the government cited on this particular theory of admissibility, you have the Dunford case, and that was the drug user in possession of a firearm case where the defendant stipulated that he was an unlawful drug user, but nevertheless, over a Rule 403 objection, the government was allowed to present evidence that drug paraphernalia was found inside the home when a search was executed. In that case, the drug evidence was more evidence of the same type that was stipulated to. And that was part of the telling of the story of how law enforcement came in and was able to search.
Why wouldn't this be evidence of the same type?
Because it is substantially more prejudicial. If it was just more evidence of the fact that Miller knew her age, we wouldn't be here. This is evidence of a whole other crime, and one that the government has spent pages, both at the district court level and here, to describe how horrific this additional crime is, such that
Why does the fact that it might be the subject matter of another crime matter? I mean, I know it's. I get. The fact that it may be criminal in another way may be prejudicial to your client, but is it unfairly prejudicial?
it is unfairly prejudicial.
Why? Why is the fact that if you assume it's relevant, if it happens to be criminal in another way, why should that make it unfairly prejudicial?
One, because the probative value of the evidence is so small, but two, incest has long been a horrific, taboo topic, crime, something that is very likely to incite the emotions of the jury to the point where if this is a closed case, the fact that they had some relationship beyond an adult and a minor is likely to sway the jury and say, well, this guy was doing this to his, and it's an adopted sister, that's in the record, but I want to note that. But nevertheless, it's likely to sway the jury. And absent some better ground to admit that evidence, its probative value is so minuscule that it should stay out. And that was one of the key discussions in Old Chief was when evidence is not contested, the district court can balance the very minute amount of probative value when making a 403 assessment.
So what's your best case as a derivative of Old Chief?
In this instance, Your Honor, the government, we concede, is entitled to present a witness to testify that Miller was interviewed and admitted that he knew MM was 14 years old, and no more. And they're not required to stipulate to that, we understand that, but Old Chief also says that in making a 403 balancing decision.
Well, what I'm asking you is, do you have a case that comes after Old Chief that supports your position?
Ham was a Fourth Circuit case that we cited. That was a RICO case where the defendants were running a Hare Krishna community.
Right, but how does Ham help you here? I mean, the evidence they wanted to get in that case had nothing to do with the crime.
It was offered as motive, as supportive of the element of motive. And I would, the fact that MM and Miller were adopted brother and sister in this case is also not related to the crime. If you look at the elements of the offense with which he is charged, this is not an enticement offense. This is a providing material, obscene material to a minor case. Obscene material is required to be judged on its face without any additional evidence of context. And given Miller's admission that he knew how old she was, it is of very minimal probative value on the element that he knew her age. I want to conclude, and I'm glad I got a chance to get this in because in the public defender's office, we don't often get a chance to cite the standard of review and rely on it. This is a plain abuse of discretion standard on review. At the time the district court made its ruling, the government in its trial brief had noted that given the parties' stipulations, the issue before the jury in this case is very narrow. Whether the letter sent by defendant to MM is obscene. As such, the United States anticipates that its case in chief will be brief with few, if any, legal issues remaining. That's from page 25 of the joint appendix. The government kind of walked that back and argued the issue of its relevance to the issue of Miller's knowledge of her age. But in making its decision, I think the district court rightly recognized that the issue of Miller's knowledge of her age was of minimal importance in this case, and further concluded rightfully again that extraneous evidence, additional evidence of context, was not relevant to the issue of obscenity. And in so concluding, the district court did not plainly abuse its discretion in concluding that evidence should stay out, and for that reason should be affirmed.
Thank you, Mr. Page. Ms. Harrell?
Thank you. Thank you, Your Honor. A few points just of response. I think one thing that obscenity cases are challenging in determining how you determine obscenity. But I think there is some degree of conflation being made by defendant between the prurient interest prong and the patently offensive prong. The United States would agree that patently offensive does relate just to the words on the paper. And it's whether the words on the paper describe sexual activity in a patently offensive way. And those specific descriptions are just the literal words that are used. The prurient interest prong looks to the work as a whole. And I think Judge Rushing made a good point about when you look at the work as a whole, you have to understand what the work is saying. And when the author and the recipient would have had that inside information, to withhold it from the jury is to not let them know the work as a whole. So I think there is a bit of a distinction between literally just looking at the four corners and looking at the work as a whole, which does require the jury to at least know what is being described. In terms of the question as to the old chief commentary about weighing the evidentiary value when there is a stipulation, that was actually much narrower than what the defendant is arguing. It talks about when the stipulation is the evidentiary equivalent. And in Old Chief, when you're talking about a status, that is, the weight of that evidence is an evidentiary equivalent. In this case, evidence that is a stipulation that simply tracks the language of the statute is always going to be second best to the actual facts of the case. And that is why Rule 403 and Old Chief say that the facts of the case, the defendant does not get to withhold those just because they look bad for the defendant. And these facts do look bad for the defendant, but that is not a reason to exclude them. And I think the Grimman case is helpful in that respect, because if you look at that, the evidence that was permitted was that the defendant had used a firearm to engage in a shooting. He was charged with being a felon in possession. The possession could obviously have been proven through less prejudicial evidence than the fact that he had shot someone, and that obviously would constitute another crime. But the Fourth Circuit said that was not excludable under 403. The government can use its best evidence rather than allowing 403 to be a shield to protect the defendant from having the jury know exactly what he did to commit the crime. The argument also about the weight, whether it's the United States can put on a witness who has a very limited scope of only testifying as to tracking the language, that he knew that she was under 16. That's going to leave a lot of questions for the jury. How did he know? Who is this person? And as Old Chief points out, when there are gaps in the narrative, when you are presenting a mere abstraction to the jury rather than a flesh and blood victim, they're going to draw negative inferences against the government. And that is exactly why Old Chief says the United States can present its case as it chooses. And I think rather than looking at Ham, which involved, as Judge Agee said, essentially unrelated sexual activity when you're looking at a RICO case, I think looking at a case like the child pornography cases, those kind of cases are a much better example. In those cases, the government can introduce images and videos of child pornography even if a stipulation is proffered by the defense. And that's because the government can put on that evidence because it is the crime. And it often goes to multiple elements of the offense. And this evidence, the relationship, goes to multiple elements of the offense. It goes to obscenity, and it goes to the knowledge of age. And for that reason, the United States should be allowed to introduce that evidence. And it was a clear abuse of discretion for the court to exclude that evidence and essentially preclude the United States from putting on any case other than admitting a single exhibit in front of the jury. It also flies in the face of Old Chief, which talks about the government has to put on a case that meets a jury's idea of what a trial looks like. And frankly, I can't even envision a trial where we go into openings, I admit an exhibit, and then I rest my case. I think everyone in the courtroom will be left confused. And that is exactly why the United States has to be allowed to present some form of evidence to give the jury a story of the crime that happened here. And for that reason, the United States asks that the order be vacated with instructions to allow the government to introduce this evidence.
All right, thank you very much. We appreciate the argument of both. Counsel, as you know, we would ordinarily come down and greet you in person, but we can't do that now. So we hope that we'll be able to the next time you come back. So with that, we're going to take a very brief recess and come back for our last case.
the judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. We'll take up our next case. 224307, United States versus Evans. Mr. Gillette?
Thank you, Your Honor, and good morning, Your Honors, and may it please the Court. It's my privilege to represent James Casey Lee Evans, the appellant in this matter, and we're asking the Court today to hold that a defendant has not willfully violated 18 United States Code Section 1855 when his actions as he understood them were entirely lawful. That is to say, if the fire that he started, as he had a good faith belief that it was on private land and with the consent of the landowner, subsequently, if it turns out that it was on federal land, he has not willfully violated the statute in question.
So you're asking us to reach a different conclusion than the Second Circuit did in the Allen case?
That's exactly right, Your Honor. We believe that in the circumstances of the Allen case, that was a correct decision, but Allen, even in itself, held that Mr. Allen, the firefighter who was bored and was trying to start fires to keep in shape, as it were, that what he intended to do was unlawful.
But counsel, that may be true, and that may be different than what you contend occurred here. But the requirements of the statute can't be determined on that basis, can they? I mean, that was a fact that the firefighters might have known that their conduct, even if it wasn't on federal land, was unlawful. And we have to decide a rule that applies regardless.
You're right, Your Honor, you absolutely do, and this is the rule that we're proposing. If a defendant who's charged in this statute presents a prima facie argument that his conduct or her conduct, as they understood it, would not have been unlawful, then that evidence for and against the intent with respect both to the starting of the fire and the ownership of the land should be presented to the jury with instructions to consider that intent in deciding whether the defendant's actions were willful or not. The Allen case, for instance.
Are you saying here, I just want to make sure I'm clear, you're saying a defendant can make a mistake of fact defense on willfulness? Is that regardless of whether the jurisdictional element requires knowledge that it's federal land, that there would still be a mistake of fact defense if you thought you were on your own property or your client thought he was on his own property?
If I understand your question correctly, Judge Rushing, yes, that would be the answer.
A difference between a defense and the government's burden to prove the jurisdictional element.
If you are asking, is there an affirmative defense that this element is both jurisdictional and substantive, yes, we believe that that's a possibility. A mistake of faith defense would be, in a case like this, it would be a valid defense. Now, going back.
Because you can see how it would be, arson is, we know it's wrong to set fire to someone else's property, whether it's the federal government, state government, your neighbor, anyone who, it doesn't belong to you and you don't have permission. But that's different than setting fire to your own property. And perhaps that's not done with a bad mind, with evil intent, with willfulness. Now, I don't think, that doesn't sound like we're talking about whether the government has to prove the jurisdictional element, that you had knowledge with respect to that element. It sounds like we're talking about a defense particular to the defendant's knowledge in this case.
If I understand your question, Judge, I agree with that. The knowledge Mr. Evans' knowledge of ownership of that property is somewhat unique to his case because that's what distinguishes his intention to do something unlawful from his intention to do something innocent.
It makes a difference, doesn't it, whether you are saying it's an essential element, his knowledge is an essential element that the government must prove, or whether you're saying, no, or it may be that, that's not their proof, but we get to show this mistake of fact defense. So I wasn't entirely clear what, and I don't mean that in a bad way, but can you tell me what your position is? Is it the government's burden, or is it a defense you think you've been deprived of?
Let me say, as you begin to answer that question, as I understood your argument both at trial and here, it is that the willfulness element in the statute applies to both the act of arson and the knowledge of presence on government land. So I understood your argument to apply willfulness to both of those elements and not to some sort of an affirmative defense that's unrelated to willfulness.
Judge Agee, I would agree with what you just said. And the issue of knowledge that Judge Quattlebaum was raising, we clearly, as a jurisdictional element, the government does not have to prove that the defendant knew he was on federal land. As regards to willfulness, and in this particular case, his knowledge that he had left his family land and was now on government land because they abutted each other, that goes directly to willfulness. So it's easy to become somewhat confused in terms of our argument, but especially at trial, with regard to his knowledge that he was on government land. We all knew at trial that the lands abutted each other and that the question of whether he knew that he had left his family land was an important issue to determine whether he was acting willfully with the intent to do something unlawful.
Let me ask you about what happened at trial. I was trying to go back and piece this together. As best I could understand it, Mr. Evans made a proffer, or you made a proffer through Mr. Evans of evidence he would present, and then that was not allowed to go to the jury. Is that correct, or what happened there?
We made two proffers. Following the...
And these were outside the presence of the jury?
That's correct, Your Honor. The first of those proffers, after the surveyor had presented evidence about where the property was, Mr. Evans believed that he had some objective observations that he could offer to the jury that would counter what the surveyor said. And so the court granted an opportunity to present that outside the presence of the jury. Turned out that the observations that Mr. Evans had were not useful at all. The court said, no, the jury does not need to hear this, it would confuse them. We have not challenged that with respect to the observations and their relevance to the survey. The things that he did say about why he believed in the first proffer, why he believed that he knew where the boundary was, and the entirety of the second proffer, where he talked about walking the land with his father, he talked about being there 30 years, he talked about helping some of his neighbors find where the property boundary lines were. All of those things, we believe, had the jury heard that, would have helped them to understand his intention and that he was intending to do something lawful, not something unlawful.
So you were trying to make a case that went purely to mens rea on that, as you saw it on that element.
Exactly. Yes, and so we believe, and both from the nature of willfulness, from the elements of scienter, from the cases that we've argued, and from the text of the statute itself, that willfulness should be applied not only to starting the fire, that's what the court instructed, but also to the element of government ownership of the land. In this particular case, that was something that was relevant to the mens rea.
So counsels, to do that, it seems there could be several ways to do that. One might be the text compels that result. Yeah, that, it seems to me, yeah, I know you don't want to abandon that, but yeah, that might be a hard thing to do. But maybe you think that applies too. It seems like another way would be just the general canon of mens rea that the law generally criminalizes conscious wrongdoing. But yeah, and then you have I think the argument that, well, you know, when we have a situation that is jurisdictional language that in and of itself doesn't involve otherwise criminal activity, well, then maybe it's okay. So I'm just trying to, I mean, maybe you're building on all those things. Is there one that you think is your best argument? Where are you trying to go with it?
Judge, you're exactly right. We're building on all three of those. We believe all three of those are good arguments. I think the best argument from my perspective is the nature of willfulness, and that willfulness must include an intent to do something unlawful. And I think, I believe the government and we are in agreement that government ownership of the land is a jurisdictional element. I believe we're also in agreement that there's at least a possibility in a small number of cases that the jurisdictional element can also be a substantive element. Where we part company is we believe this is that case and the government believes it's not. We believe that the simple way to tell the difference between when a substitute...
So it's a jurisdictional element sometimes, but sometimes not?
We believe that a jurisdictional element is also substantive when it defines the difference between lawful and unlawful conduct.
Right.
And we believe that's the case here.
For purposes of this statute, as opposed to a general proposition on that point, is the arson of federal lands statute this prong of it that is required to prove jurisdiction? Are you saying that that's sometimes just a jurisdictional element or sometimes both a jurisdictional and a mens rea element?
We think that it's substantive when it delineates between lawful and unlawful conduct.
What about the case involving lying to a federal agent? Lying's not a good thing, but it's not an illegal thing. Doesn't the distinction about lawful and unlawful conduct, seems to have some appeal, but the cases don't limit themselves to those?
Yeah, I think you're talking about the Urmain case, and there it said, it was a formal document, I think maybe an employment document, and they said that it would be understood to be culpable, if not unlawful. It probably would be unlawful to lie on an employment application form. And the fact that it happened to be an employment, the employer was going to be the government, didn't really make any effect in terms of the culpability of the conduct. It made an effect in terms of the jurisdiction that would be applicable. I said willfulness was, I think, our strongest argument. I will mention the text of the statute, and I've briefed that, especially in the reply brief at some length. And I believe that the scienter, the cases that we have briefed also are important for that. For these reasons, we would, if there are no more questions, we'd ask the court to stand on our brief.
You're going to have rebuttal time, but
I do have a few minutes of rebuttal
yes,
time.
you do. What evidence did you present at trial that was actually heard by the jury?
Regarding this issue, very little. I think the government in its brief mentions that my client got to say once or twice that he believed he was on his own land. I think the judge actually struck that. There was some evidence presented by the government that he might have known that he was on government land when he did these actions. This is a good jury question. Juries can take this contradictory evidence and make decisions, but the judge in this case instructed them to ignore that and said willfulness only applies to starting that fire, anywhere. And if it turns out that it was on federal land, the jurisdictional element, as the court instructed the jury, this could have been a man who was trying to protect his property from an oncoming forest fire. Could have been somebody camping who had some, because of the weather, they needed to start a fire and they were in the wrong place at the wrong time. There are any number of reasons why a person who started this fire could have had some justification for it, but the court instructed the jury to ignore any of that and simply say, did they intend to start a fire? That was the only element of the offense that the court said the jury should look to willfulness for.
Thank you very much, Mr. Gillette. We'll hear from you on rebuttal. Mr. Enright.
Thank you, Your Honor. May it please the court. Anthony Enright for the United States. I would like to start by answering, I think, a very important question Judge Agee asked, which is, what evidence did the court rule on? Very early in the trial, we had a debate about a motion in limine. And the court said, I'm not going to instruct the jury. I'm going to instruct the jury that the government did not need to prove that he knew he was on federal land when he started the fire. But I will instruct the jury that the government has to prove he acted willfully. And in response to that, the defense said, well, I would like to make a proffer in case, for this court's benefit, in case the jury instructions are wrong. The defense never sought to introduce that evidence in the second proffer before the jury. And in fact, the judge asked, can we have that proffer after you've rested while the jury is deliberating? And the defense said, sure, that would be fine. And that's exactly what happened. He rested, then made the proffer, told the court it was for the benefit of this court, never sought to reopen evidence, and never asked the court to make a ruling on the admissibility of that evidence.
Is any of that in your brief?
I did, Your Honor. Well, the defense didn't raise the second proffer as an evidentiary ruling in his opening brief. So I didn't respond to that as if it had been raised. The first time I saw any argument that the court improperly excluded that evidence was in the reply brief.
I mean, I thought that was kind of the heading, right? Wasn't that the bold-faced, capitalized heading of the brief, that the court prevented us from putting on any evidence to counter willfulness?
Yes, any evidence.
His own testimony that he thought he was on his own land.
Yes, Your Honor, and that's why I took a guess. What rulings are we talking about? And I walked the court through all the rulings the court actually made on the defense evidence. Made first a ruling on that first proffer. The defense, again, said that proffer isn't about subjective intent, it's about the actual boundary. And the court said, well, that doesn't meet the requirements of Rule 701, and I did walk through that.
Yeah, it seemed to kind of morph. I read this a couple of times. I mean, you probably are more familiar, but it started out as a ruling just about, the judge said, I don't like motion in limine. You're asking me to predict what's going to happen. That's tough. I'm just saying this is a jurisdictional element. The government doesn't have to prove willfulness as to that element for an instruction. But then as it came up more and more throughout the trial, there were arguments about willfulness and that the very existence of mens rea in this case is up for dispute because, and they cited the Bryan case and said there's no bad purpose. And then the judge's ruling seemed to kind of expand and said, no, I'm not going to allow him to talk about that at all.
So I agree there was discussion about that, but I think there's a lot of discussion, much like the discussion we're having here. The court asked the defense about it, well, what is the relevance of his subjective intent? And that, I think is fair. Sometimes the court made statements to the effect of, I don't think it's relevant. But ultimately, when there was a ruling made, excluding evidence or giving the jury an instruction, the court made the correct rulings, and rulings the defense agreed with, especially with the instruction. The court instructed the jury that it had to find willfulness, and that willfulness requires intent to do something the law forbids. And the defense, when at the charge conference, says that was an entirely proper instruction on willfulness. The jury had to find that he knew his conduct was unlawful, and that is all that willfulness requires.
And do you agree that, putting aside the jurisdictional element, let's put aside what the government had to prove there, but that it would be a complete defense to the mens rea element, it would be a complete defense to willfulness if he thought he was on his own property?
No, Your Honor, I do not agree with that. I believe that it would be a complete defense.
Well,
if
that
he-
would have to be willfulness as to this jurisdictional element.
Not necessarily, Your Honor. If he believed he was on his...
Well, I mean, if somebody starts a fire,
Yes,
he
Your Honor.
knows he starts the fire. You assume there's no factual dispute that it was somebody else that started the fire.
That's correct, Your Honor.
That's your first prong,
Right.
right? But then you have to show that it was a fire on government property.
Yes, Your Honor.
So, let me give you a hypothetical that isn't, I don't think, too far out of the realm because I've seen these cases. So, the government presents its case as a surveyor, qualifies as an expert, because these are the lines. More testimony, layer expert, here's where the fire was. Then you have a defendant who produces a survey. And so the experts go back and forth, and the jury finds that the arsonist's survey was incorrect. There was a defect, that the survey included property that when you went back and traced the deeds back far enough, that the calls were wrong. So,
I'm sorry, Your Honor. I think I missed that last phrase. This is the jury found that the accused arsonist survey was incorrect.
that survey was incorrect. They went back in time, somewhere along the line, chain of title, the calls got mixed up. Or the surveyor, for whatever reason, he made a mistake. So the jury finds, indeed, the fire occurred and this property was on federal land. Is your case complete as to that element at that point?
As to the elements of setting a fire and setting a fire on federal land, yes, under your hypothetical, there's evidence that the fire actually was set on federal land.
So is that it at that point? What
No.
defense does a defendant have?
The defense's defendant would be, I believed when I set that fire, that the fire was lawful. Now, there's a big distinction between that, and I knew that the fire was on federal land. And the reason is because willfulness requires us to prove that the defendant believed his conduct was unlawful, but it does not require us to prove that he knew why it was unlawful. So if he believed he set the
So
fire...
how's that any different from what this defendant in this case wanted to tender as evidence?
Your Honor, I don't, so one challenge I have is that what the defense has said today is a little bit different from what he told the district court. He did not ask for a charge. He started today by saying he should have had a charge that he did not willfully violate the statute if his acts were entirely lawful.
Can you just focus on the evidentiary question that Judge H is asking? What's different between the hypothetical you two were just talking about? He can show that his conduct he didn't know he was violating, he didn't act with an intent to violate the law, right? A bad purpose. And if here he wanted to show that he thought he was on his own land with permission, that he wasn't, how is that different as an evidentiary matter?
If he showed that he was on his own, he believed he was on his own land, we could still establish willfulness if we could establish that he believed his conduct was nevertheless unlawful. And there's plenty of evidence to that effect.
So he believed he was
Well,
on
wait,
his
if he
own
be-
land with permission, but
He-
that it was unlawful.
Yes, and in this case, there's evidence that he told police officers that he wanted to burn the entire top of the mountain off that he knew belonged to the federal government. If he believed that he started it on his own land and that was his purpose, that's
Right.
strong evidence that he believed it was unlawful, as is the evidence that he
But wouldn't a
told.
jury have to hear both sides' arguments about that and decide? I mean,
Certainly, and
it's
he
not
did.
irrelevant that he thought he was on his own property at that point.
Oh, it's not irrelevant, Your Honor. We're not saying it's irrelevant. The defendant asked the court to charge that we had to prove he knew he was on federal land. That is not our
Yeah, I
burden.
guess, I'm not disputing the jury charge here. I'm thinking more about his testimony that was excluded.
So he testified not once or twice, 5 times. 5 times he told the jury, I was on my father's land. And I told,
He was on what?
on my father's land when I started
Okay.
the fire. 5 times. One time he said it directly, 4 times he said, that's what I told Agent Blaine when he asked me while the fire was still burning. He made a proffer after the jury rested again and said the same thing with more
Well, he said
development.
with more detail, right? He said, you know, here's how I know, right? For the years I've walked the land, here's the boundaries, here's how I know. And so the question then is, can we say that that exclusion of that testimony was harmless because the jury heard him say that he thought he was on his
I think
father's
you
land?
could, but I would prefer you go back to the first part of the way you phrased it, which is the court never excluded it. The defense never once asked the court to allow the jury to hear that evidence in that section of
So
proffer.
your argument seems to be more, you know,
Can I ask something about, I thought, going back to what Judge Rushing had gone through earlier, I thought the district court had said several times, I'm not letting any of this in.
There's 2 proffers, Your Honor. And the first proffer, the defendant said, the defense counsel said, I want to introduce evidence of the actual boundaries. I want to introduce evidence of the actual boundaries of the Forest Service. And as my friend mentioned, that was to counter our survey expert. In other words, the objective boundaries. And he said, that's what I want to introduce this evidence for, and I'm going to have
Well,
Mr.
I thought there was a discussion between Mr. Gillette and the district court at some point about, we want to put on members of the family and/or Mr. Evans, and they want to describe how they arrived at this belief.
Yes, Your Honor, we're talking about the same thing, I think. But-
So maybe I've just read this wrong, but I thought there were several places where the district court said, no, that's coming in. End of story.
That's true, Your Honor, but I think there was a context for that. And it was in the context of the defense saying, I want to introduce evidence of the actual boundary of the forest. And what the court was saying was,
Well, that was after, I mean, Judge Reidinger had already ruled that this is not coming in unless, he said, there might be a fact issue if you disagree about where the actual boundary is. And so the defense tried to meet that particular factual issue, but that wasn't all
Your Honor,
the only evidence that was excluded.
before that time, the defense had not begun its case, and there was no definitive ruling on any particular evidence. The court made an abstract ruling on the motion to eliminate. Our motion to eliminate was to preclude evidence and argument that knowledge that he was on federal land is an element of the offense.
So on 362, the court says, the subjective belief of the defendant as to whether or not the place where the fire was set is government land or the land of another or the land of the defendant would not be relevant. It is a question only of whether the property is actually owned by the government. And that's in response to the defense saying, if our witnesses aren't able to explain why they believe this is owned land, we're precluded from answering the charge.
And that would seem to be the rule from the Allen case. And I guess what we want to know is that rule, very specific, is that the position of the government?
Is that our position is the position of the Allen case. Allen holds that we do not have to prove that he knew he was on federal land, but our position is absolutely that we had to prove that he acted willfully and that he knew his conduct was unlawful. And we told the court that in the district court. We said that at the initial Rule 29 motion, and we suggested the jury instruction from Bryan, which is you have to have intent to do what the law forbids, which the court endorsed. The jury was required to find beyond a reasonable doubt that the defendant knew his conduct was unlawful, and he argued that in front of the jury. He said the government did not prove its case if you find that he went up on that mountain and did not intend to do anything illegal.
So do you disagree with the district court statement here that under the standards set out in Allen, whether he believed he was on his own land is irrelevant? You agree the government doesn't have to prove whether he believed he was on his own land or not, but do you agree with the district court that it's irrelevant?
The idea that I don't agree with that in the abstract. The idea that it's irrelevant is not a complete statement of the law. I do think there's a context here because on 361 the court says, I believe the witnesses for the defense believe that the land the fire started on was in fact privately owned land or belonged to the Evans family. And he told the court repeatedly his goal was to counter the survey expert. And I think the court understood that because the court said, I want to hear a proffer, I have the language here, don't remember the page number, but the court said, I want to hear a proffer regarding boundary ownership, regarding the actual boundaries.
In effect, he wanted expert testimony because there's a lot of discussion about the government's had an expert. It looks like to me, defendant, you want to put on expert testimony, but it comes through and a lay witness can't do that.
Yes, Your Honor, I think that's exactly right. The court was expecting, because it's a survey, it's something you usually do through meets and bounds with specialized equipment. He was expecting a survey. The defense said, well, I want to have Mr. Evans introduce that evidence, and that's why the court wanted to hear a proffer. I want to hear a proffer to see if you can lay foundation to establish that your opinion about where Forest Service territory ends is admissible. And he didn't meet that standard. And from what I understand, the defense isn't even contesting that. But he doesn't address Rule 701, and 701 requires lay testimony be based on personal knowledge.
Let's go back for a minute to the first question I asked you about, where you've got the battle of the surveyors.
Certainly.
The defendant's survey turns out to be wrong. So you've proved there was an intentional fire set. And it turns out the fire was on land owned by the federal government. Do you rest at that point?
No, Your Honor, we would also want to prove that the defendant acted willfully. And the reason we have a
Acted willfully to do what?
He set the fire with knowledge that setting the fire was in some general way unlawful. So we would, in that type of a case, want to have evidence that he said something. He had said something to the effect of, well, I intended to burn someone else's land, or I knew I was going to jail, or I believe I broke man's law.
So if, not in this case, but using the hypothetical, if there were no evidence of these other statements, and all you had was, we showed there was an intentional fire set, the fire was on federal land, and you can't show anything else.
That would not make our case.
So he'd be entitled to a judgment of acquittal at that point.
If there were no evidence of, I mean, it's a hypothetical, but
Right.
if there were no other evidence of willfulness, that is knowledge subjectively. And the flip side's true too. If he believed he was on federal land, but he had an honest belief that his conduct was lawful, that would be a complete defense also.
Like if he thought he had permission.
If he thought he had permission, and it was permission from the government,
Right.
not permission from his mother,
Right.
but permission from the government, that would be a complete defense. That's why willfulness operates to distinguish culpable conduct from non-culpable conduct, even though this element is jurisdictional. He has to have known his conduct was generally unlawful. But what this court held in Bishop, which is interpreting the Bryan standard that we all agreed on for willfulness, is that we don't have to prove that he knew why. So if he was on his land and he started a fire and he believed it was unlawful, that's just not a defense, the fact that he was on his land. There's many reasons you could burn a fire on your own land and have it be unlawful. You intended it to spread to others. That's a federal statute, another federal
So
statute.
if the state statute, as it does in Virginia, for instance, prohibits outdoor fires before 4 o'clock between February 1 and April 1. And this fire was set on March the 1st. That would be sufficient because it was clearly an illegal fire even though it was on his own land.
Well, no, Your Honor, it's not whether it's illegal under some other hypothetical, it's whether he believed it was illegal. So if he believed it was illegal and was mistaken about that, about why, that would not be a defense. And if he believed it was illegal because it was a violation of Virginia law, even Virginia fire law, but it was actually a violation of 1855, that would also not be a defense. The standard under Bryan is you have to know that it is in some general way illegal, but you do not have to know the specific duty you are violating. And the Bishop case and the Cooper case, they don't draw any distinction between something that's a regulatory crime or a statutory crime.
But it sounds like you're saying that, and I know that there's evidence from which you could argue and did argue that he, had he knew he was acting illegally because he was talking about, burning down the whole mountain.
Absolutely, and he specifically told the police officer, "You're going to take me to jail because I violated man's law."
I got you, but in the mix for determining whether he knew he was acting unlawfully, you believe, it sounds like, he should have been able to talk about why he thought, or this was his land or he had permission. You don't think admitting that would be wrong, and you think this was more of a failure to proffer it that way?
It was. I mean, I want to mention the court. He did introduce that.
I know he said
without
5 times,
objection.
but he didn't get to. He didn't introduce what he said he wanted to, and maybe that was a failure, kind of presenting evidence or proffering evidence.
I think that may be a big part of it, to the extent the defense is arguing that evidence that came in that second proffer should have come in, or that some of the evidence from the first proffer should have come in, because the defense is the one that said in that first proffer, this is evidence about the boundary.
But the second proffer,
After the defense rested.
if that had been made, before the defense rested, is it the government's position that it would be proper evidence to on the issue of whether he knew his conduct was unlawful?
On that issue, yes. I think it would help if he had mentioned that to the court. I want to introduce this for the purpose of proving willfulness.
And you don't think the court's rulings pretty much told him he couldn't do that?
No, Your Honor, because he didn't present it that way. He didn't ask the court to say, I want an instruction that I had to know my conduct was unlawful. I'm sorry, Your Honor, I know I'm over time. May I answer Judge Quattlebaum's question? Had he presented it that way, he very specifically presented this as an opposition to a motion in limine to preclude evidence and argument that knowledge that he's on federal land is an element we had the burden to prove. And the jury instruction he requested was the government has the burden to prove he knew he was on federal land, completely divorced from knowledge of illegality. Had he presented it as this is evidence of willfulness, I think we wouldn't have opposed it. We told the court that. And when he sought to...
I think he did, didn't his brief cited Bryan and quoted that willfulness requires a bad purpose and that this evidence goes to show that he didn't have a bad purpose?
He cited Bryan when asking for a jury instruction, and he got the jury instruction that he said was proper.
I think that was in response to the motion limine. I might be wrong, but...
That's true, Your Honor, but the motion in limine was abstract. It didn't rule on any particular evidence. It said he won't be allowed to introduce evidence that there's an element that the United States has to prove as an element that he knew he was on federal land. But the court in that response said, I will instruct the jury that he had to have acted willfully. And if he wanted to introduce evidence that he didn't act willfully, that ruling did not preclude him from doing so. I'm over time, so with that, I will...
All right, thank you, Mr. Enright.
Thank you, Your Honor.
Mr. Gillette?
Just briefly on a couple of issues. The blessing and the burden of being trial counsel is that I was there for all of the things that took place, and maybe get blinded to the forest for the trees. But it certainly, I would disagree with my friend's characterization that it was just a matter of we forgot to ask the court to let the jury hear this. No, from the very beginning, from the government's motion in limine, when the government said that the court should preclude any evidence that he thought he was on his own land, to the motion as it was argued at the beginning of the trial, several times throughout the trial it came out, we wanted to introduce evidence that he believed he was on his family land, and the court said no. And the court, even that first proffer had a dual purpose, both to present objective evidence, but also to present evidence of belief. And the court said, no, whatever it is that your client believes, that would confuse the jury. That was the court's word. That would confuse the jury. So yes, all the way through, we tried to introduce the evidence, the type of evidence, if not the exact evidence, that came into that second proffer, and the court shot us down every single time. So I do take issue with the idea that this is just, we forgot to ask the court to let the jury hear this. In terms of willfulness, I think at this point in time, we may be, approaching some types of consensus on what would be a justifiable defense. But it's different from what the judge charged the jury. This is what the judge said. Therefore, ladies and gentlemen of the jury, I charge you that if you find from the evidence beyond a reasonable doubt that at the time and place described in the superseding bill of indictment, that the defendant set on fire timber, underbrush, or grass, and that the defendant in setting the fire did so willfully, and that such fire was set on lands owned by the United States, then you should find the defendant guilty. Clearly, whatever evidence the jury heard or might have heard regarding whether the defendant, Mr. Evans, believed he was doing something culpable or not, the judge charged the jury to ignore it and confine itself to, did the defendant set a fire willfully, any fire, anywhere, anytime, and remove that entirely from the location of the fire being on United States land.
You objected at some point to that instruction?
Yes, we absolutely did. We got the judge to include a short sentence defining willfulness and making reference to culpable conduct, and then the court inserted that into the middle of a paragraph where everything before and everything after went to vitiate what we had asked the court to include. And it was a contradiction. The court's charge on willfulness at our request, and with the government's consent, said that willfulness requires culpable intent. And then the court went around and said, no, the only intent is regarding setting the fire. And as even my friend here has acknowledged, that setting a fire is not always, in fact, in many cases, not at all culpable. The court, I think, in this jury instruction confused the jury by restricting the element of culpability or the need for culpability to the point of non-existence.
Got anything else for us, Mr. Gillette?
I think that's it, Your Honor. If there are no more questions, we thank you.
All right. We thank both counsel for an excellent argument today. Mr. Gillette, we noted that you are court-appointed. The court wishes to express its appreciation to you for undertaking representation in this case, because we could not perform our functions in the criminal justice system unless members of the bar like you were willing to step up and represent indigent defendants. So normally we would come down, as you know, and greet counsel in the will of the court, but we're COVID barred still from doing that, so we hope when you come back the next time, we'll be able to come down and greet you. With that, we'll ask the clerk to adjourn court, sine die.